Thank you. For those who don't know me, I'm Konstantinos Vouterakos. I'm a lawyer partner with KG Law Firm and the chairman of the Association of Greek Law Firms. I will be moderating this interesting panel with a very challenging topic. We have excellent speakers to speak about something which is very, let's say, it's a very critical and interesting topic for the judicial legitimacy. A few words from me before I pass the floor to the speakers. What are we going to discuss about today? Judicial legitimacy refers to the public's perception that the judiciary is impartial, reliable, and the authoritative interpreter of the law, reaching decisions based on principles, without bias and without external pressure. So when this public trust to the judicial legitimacy erodes, the rule of law is undermined, threatening, amongst other things, the democratic governance and the social cohesion. Social media and artificial technology are two different matters, but they meet and interrelate, interconnect due to their reliance to technology. And it's frenetic, and I dare to say frantic, if you want, development over the last 2 decades. The main characteristics of social media is the rapid dissemination of information, often in an unfiltered, direct, and irrational manner. And the second characteristic is the power of the image, which creates a high-speed connecting unrelated people in different environments and forming a new meta-public opinion, stronger perception, if you want, from the real thing or the real situation. On the other hand, the AI poses two different challenges to the judicial legitimacy. First of all, it amplifies the power of the social media by enabling algorithmic content curation, deepfakes, and automated engagement. And at the other hand, challenges the very same operation of the justice by AI-assisted legal reasoning and opaque algorithms, thus posing threats to transparency, fairness in decision-making, and accountability. So with this in mind, I would like to present our two esteemed speakers who will elaborate over the topic and will present their views as to how the interaction between technology challenges and the process of justice works. I would start first by reversing the protocol that ladies goes first with our Honourable Peter Quinlan. He's Chief Justice of the Supreme Court of Western Australia and Lieutenant Governor of Western Australia since August 2018. Prior to that, he was holding position as a judge of the court, judge of the Court of Appeal, and Chief Justice of Western Australia. Between 1996 and 2001, he was legal officer at Western Australia Crown Solicitor's Office before joining the independent bar in 2001, and he was appointed senior counsel in 2010. He was also appointed Solicitor General for Western Australia in 2016, up until his appointment to the bench. Peter graduated from University of Western Australia with a Bachelor of Commerce and a Bachelor of Laws first-class honours. He also served as a president to the Western Australia Bar Association in 2012 till 2015, and the Board of Governors at the University of Notre Dame, which is one of the most prestigious private research universities in the world. This is all impressive, Peter, and with you covering really the full range of the legal positioning and the various hats you were wearing in your entire professional career, we are very interesting to hear your views on this topic. So you have the floor. Thank you.
Thank you, Konstantinos, for that welcome, and thank you all for the invitation to be with you at this most important summit of Hellenic lawyers. One thing that Konstantinos left out was that I am also the patron of the Western Australian branch of HAL, the Hellenic Australian Lawyers, and I think I'm right in saying that I have the privilege of being the only state patron that is not of Hellenic origin, but it shows that the Philhellenes can also be the patrons of that great organisation. One of the critical word in our topic this afternoon is trust. And before I come to the remarks that I'd prepared, I was reflecting with some of the other delegates last night in relation to the issue of trust, and we'll be talking about trust in the judiciary and trust in other government institutions. But there's also a question of trust of AI. And trust is a very complicated thing because often we think about trust and act quite differently. And AI is a good example of it, of course, because there is a lot, and we've heard parts of it in the conference so far, of a certain element of distrust that we have of artificial intelligence, notwithstanding the fact that we are all, at all times, instinctively and inherently trusting it with all sorts of activities that we carry on day by day. There would not be a person in this room who has not benefited from the use of artificial intelligence at some point during the course of this conference. But distrust, we know, comes through our popular culture. One could go back to the Terminator series, in which the artificial intelligence computer Skynet took over the world. We could go to Charlie Brooker's dystopian series Black Mirror, that so often deals with the impacts of artificial intelligence. But perhaps the earliest example of distrust of artificial intelligence, which, as it turns out, so appropriately meshes with this conference, came from the 1968 film 2001: A Space Odyssey. Justice Rachel Gray has asked for credit for these references, and so I dutifully give it now. So 2001: A Space Odyssey, of course, apart from the fact that the name of the film refers to Homer's second great epic and Odysseus's journey from Troy to Ithaca over that long and winding period of 10 years, also had an artificial intelligence computer on it that effectively rebelled against its human masters. The famous line from the film is when Dave, one of the astronauts, says to the computer, which is, its full name is the Heuristically Programmed Algorithmic Computer. Its shorthand is HAL. And the famous line from the film was, "Open the pod doors, Hal." And Hal responds, "I'm afraid I can't do that, Dave." And it was appropriate then that it was pointed out that HAL may be an indication of a dystopian computer, but is also importantly the shorthand for the Australian Hellenic Australian Lawyers Association that brings many of us here today. So, moving on to what I was going to talk about. A little less than 2 months ago, on the 21st of May this year, the Scottish-born philosopher Alasdair MacIntyre died at the age of 96 in his adopted homeland of South Bend, Indiana. MacIntyre's life work, particularly from the time of his 1981 treatise After Virtue, was focused on a conscious revival of Aristotelian virtue ethics. Perhaps more than any other contemporary philosopher, it was MacIntyre who sought to return to virtue ethics as an antidote to what he described as the shrill tone of contemporary moral debate. And in that endeavour, MacIntyre identified Aristotle as the protagonist against whom he matched the voices of liberal modernity. MacIntyre's work and his belief that Aristotelian tradition could be restated in a way that restores intelligibility and rationality to our social commitments, provides a timely stepping off point for this afternoon's topic, challenges to judicial legitimacy, the impact of social media and AI on public trust in the judiciary and government institutions. In the first place, as I'll come to, McIntyre's diagnosis of the parlous state of moral disagreement in our contemporary world explains much of the impact of social media on trust in the judiciary and other institutions, including the legal profession, and the ongoing threat that social media poses to those institutions. And in the second place, of course, our conference meets in the city in which Aristotle produced all his major work, including the Nicomachean Ethics. It's notable that unlike his tutor Plato's Republic, Aristotle's Ethics does not explicitly deal with the quality of trust in any systematic way. Trust or trustworthiness does not appear as one of the virtues discussed at length in the Ethics. And when trust is referred to, it is not in the sense in which we use it as public trust, the quality upon which judicial legitimacy depends, but on the relationship of trust that exists between persons, and in particular, between friends. Friendship, of course, Aristotle identified as a kind of virtue and necessary for living. And the perfect form of friendship that Aristotle identified was that between those who desire the good of the friend for the friend's sake and not for reasons of utility or pleasure. And it was in that context that Aristotle invoked the notion of trust. He said this, that such friendships are rare is natural because men of this kind are few. And in addition, they need time and intimacy, for as the saying goes, you cannot get to know each other until you have eaten of the proverbial quantity of salt together. Nor can one man accept another, or the two become friends, until each has proved to the other that he is worthy of love and has won his trust. Those who are quick to make friendly advances to each other have the desire to be friends, but they are not unless they are worthy of love and know it. Trust in this context then is something that is won, and it requires time and intimacy and is the product of affection. But what of public trust? That which is repose in an institution or a profession and which is necessary for the health of those institutions. How does it compare to the trust that exists between friends? And how does Aristotle's necessary relationship of friendship compare with the relationship between the citizen and the professional judge or lawyer? Well, in the first place, there are some important similarities. The first, most obviously, is that both relationships are characterized by those in the relationship willing the good of the other for the other's sake. Recall Aristotle's description of perfect friendship. Quote, and it is those who desire the good of their friends for their friends' sake that are most truly friends, because each loves the other for what he is and not for any incidental quality. This, I'm sure you'll recognise, precisely captures one essential aspect of the professional relationship between the lawyer and the client, namely that it is a fiduciary relationship. That is, that the lawyer's duty is to act in the interests of the client and not in the lawyer's own interest. So the commitment to the good of the other as other is the distinguishing characteristic of both Aristotle's conception of perfect friendship and of the professional notion of a fiduciary relationship. And the same applies to the judicial office. It's not often that we conceive of the judiciary and judicial officers as having fiduciary duties, no doubt because they are not enforceable as such. But when it comes to the essential nature of the judicial office, that is precisely what the duties of a judicial officer are. It is in the very nature of the judicial office that in exercising judicial power, the judicial officer is not free to pursue their own separate interests, but must act only as the law requires. Indeed, in the case of a judicial officer, the relationship between the repository of power and the person in relation to whom it may be exercised is even more pronounced in its fiduciary character. That is because the power exercised by the judicial officer, in relation to which he or she is not free to pursue their own separate interests, is not, at least directly, freely and voluntarily given by the subject of that power, as is the case in the power exercised by a lawyer. You can choose to enter into a relationship with your lawyer. You cannot choose your judge. But in either case, we can see that the judge or the lawyer must exercise their powers not for their own benefit, but for the benefit of another person or group. And as in the case of Aristotle's perfect friendship, the existence of that relationship, if it is to be legitimate, depends upon trust being reposed in the judge or the lawyer that he or she will actually exercise their powers in that way. It is here that public trust, however, the trust that is reposed in a judge or a lawyer, differs from the trust that is reposed in a friend. And why it is that the notion of trust in a lawyer or a judge is inseparable from, and indeed synonymous with, trust in the judiciary or the legal profession as a whole. Trust in the judiciary, the legal profession, or any other governmental body is necessarily institutional. Professor Robert Sokolowski captured this idea in the following way. He said this, quote, "The relationship between professional and client is a fiduciary relationship. The client trusts the professional and entrusts himself or herself, not just his or her possessions, to the professional. The professional is presented as trustworthy, not primarily in the way a friend is found to be faithful, by having proved himself or herself in many situations, but by having been certified as a professional. There is an elegant anonymity to professional trustworthiness. If I get sick away from home and go to the emergency room of a hospital, I can in principle trust doctors and nurses I have never met before. I enter into a relationship with them because they are presented as members of the medical profession, persons who are certified by the profession and who can prima facie be taken as willing to abide its norms. I do not have exactly the same kind of trust if my car breaks down somewhere away from home. I am delivered over rather to the personal honesty, trustworthiness, and competence of the local mechanic. It is as though I had to find a temporary friend rather than be able to appeal to a professional." As Sokolowski makes clear, the elegant anonymity of professional trustworthiness is precisely the opposite of the trustworthiness of a friend, which is won through time, intimacy, and affection. If I can appeal to a professional, I do not need to find a temporary friend. That is because whatever trust I repose in the professional must be reposed in them precisely other than by reason of their personal honesty, trustworthiness, and competence. I must be able to repose trust in the judge or the lawyer by reason of, and only by reason of, their forming part of an institution or profession. This elegant anonymity is manifest in the oath by which an individual member of an institution or profession incorporates themselves into that institutional profession itself. While the trustworthiness of a friend is won through time, intimacy, and affection, for example, the judge explicitly swears or affirms that he or she will do right to all manner of people according to law without fear or favour, ill will or affection. Put another way, while the trustworthiness of a friend is won through and depends upon the friend's subjectivity, his or her capacity for intimacy and affection, by contrast, the public trustworthiness of the judge or lawyer is dependent upon the judge or lawyer's objectivity, his capacity not to act in accordance with affection or ill will. This highlights an aspect of the rule of law and judicial legitimacy that is so obvious that it is sometimes overlooked, namely that laws are objective standards. In a society that observes the rule of law, the law exists logically prior to and conceptually outside the mind of any single individual. Laws are, of course, as Professor Stone put it, socially derivative and non-autonomous, but once made, they are objective in character. That's, of course, the whole point. Under the rule of law, we are ruled by objective laws and not by the whims or preferences of persons. Of course, however, those objective laws must nevertheless be exercised and executed and applied by human beings. The law is, after all, a human institution. Nevertheless, the rule of law presupposes that laws will be interpreted and applied objectively, and so it presupposes that the objective interpretation and application of the law is something of which human beings are actually capable. The particular human beings, or as Blackstone would have put it, the peculiar men, that the rule of law presupposes are capable of doing this, of course, are the judiciary and more broadly the legal profession. The rule of law, therefore, presupposes that there can exist people who are able to apply the law free from the vagaries of personal whim or influence. For this reason, public trust in the judiciary requires at least two prerequisites. First, that the persons appointed to judicial office are, in fact, capable of objectivity. In other words, that objectivity is not in the end an illusion, but a real human faculty. And we, as judges and lawyers, of course, take this as axiomatic, notwithstanding a good deal of postmodern philosophical effort to the contrary. The second prerequisite to that public trust, however, is not only that we, judges and lawyers, take the human faculty or capacity for objectivity as axiomatic, but that the public too recognise that capacity for objectivity and have confidence that the institution of the judiciary can and does adhere to it. It's here that I return to McIntyre's diagnosis of the state of moral disagreement in our world and the impact of social media in the judiciary and other institutions. Early in After Virtue, McIntyre observed in relation to the state of moral disagreement in our world that, quote, the most striking feature of contemporary moral utterances is that so much of it is used to express disagreements, and the most striking feature of the debates in which those disagreements are expressed is their interminable character. He said, I do not mean by this just that such debates go on and on and on, although they do, but also that they apparently can find no terminus. McIntyre identified much of the cause of this predicament as coming from the philosophical standpoint known as emotivism. He described it this way. Emotivism is the doctrine that all evaluative judgments, and more specifically all moral judgments, are nothing but expressions of preference, expressions of attitude or feeling, insofar as they are moral or evaluative in character. Moral judgments, being expressions of attitude or feeling, are neither true nor false. An agreement in moral judgment is not to be secured by any rational method, for there are none. It is to be secured, if at all, by producing certain non-rational effects on the emotions or attitudes of those who disagree with one. We use moral judgments not only to express our feelings and attitudes, but also precisely to produce such effects in others. Now, emotivism, as a theory of morals or other value judgments, is obviously contrary to the first of the prerequisites I identified as necessary for trust in the judiciary, namely that human beings are capable of objectivity and that rational objectivity is a real human faculty. And as I've said, we as judges and lawyers take that human capacity for objectivity as axiomatic. And so, at least formally, we take it as axiomatic that emotivism is false. As a broader cultural phenomenon, however, I would suggest, following McIntyre, that emotivism is all too real. As McIntyre put it, to a large degree, people now think, talk, and act as if emotivism were true, no matter what their avowed theoretical standpoint may be. Emotivism has become embodied in our culture. McIntyre made that observation in 1981. If it was true 44 years ago, how much more so has the advent of social media and the curation of social media content by artificial intelligence embedded emotivism into our culture? Indeed, together with what Charles Taylor characterised as expressive individualism, social media has taken emotivism to entirely new levels, where an understanding of evaluative judgments as merely expressions of personal preference now is the avowed theoretical standpoint of most of its users. Any passing knowledge of social media reveals this to be the case. Evaluative judgments and indeed assertions of fact or material reality on social media are almost always expressed in highly personalised terms and as proceeding from one's own inner experience. Indeed, we often see in online discourse that the application of an external standard, any external standard, is regarded as an affront to and an attack upon a person's personal integrity or well-being. To a greater or a lesser degree, this is the culture in which we all operate and to which we all conform. And to be clear, this is not just that misinformation or outright lies are commonplace on social media and that such content appears alongside information that might be thought to be accurate or considered. The impact is much deeper than that. The very medium of social media and other forms of online, and I use this in quotes, debate or communication, is specifically not intended to engage in rational discourse or dialogue. Indeed, content on social media is in large measure not communication at all. If by that we mean communication is a process of sharing one's portion of reality with the other. On the contrary, the purpose of social media post is not to communicate, but to display. And specifically to display one's own preferences, feelings, or emotions as a mark of personal integrity or identity. In this sense, communication via social media accentuates what Plato regarded as the limitations of the written word when compared to oral dialogue. In Phaedrus, Plato had Socrates describe those limitations in the following way. He said, "You know, Phaedrus, that is the strange thing about writing, which makes it truly correspond to painting. The painter's products stand before us as though they were alive. But if you question them, they maintain a most majestic silence. It is the same with written words. They seem to talk to you as though they were intelligent, but if you ask them anything about what they say from a desire to be instructed, they go on telling just the same thing forever. If the written word just goes on telling the same thing forever, how much more so on social media, which doesn't just go on telling the same thing forever, but positively screams it." Again, anyone with a passing knowledge of social media will be familiar with this phenomenon. Interlocutors on social media do not persuade, debate, or even argue with one another. They destroy, demolish, or defeat one another. This is the absence of true rational exchange, I want to suggest. But that's not the underlying problem here. That is rather the symptom. The symptom, it is a symptom of tacit emotivism, the notion that all evaluative judgments are merely expressions of preference, feeling, or attitude, and that the purpose of politics, education, and media is merely to provide a platform for their expression. And with that assumption, the assumption that all evaluative judgments are radically and essentially subjective. Social media didn't create this phenomenon, but it has, for all intents and purposes, universalized it. And it is this radical subjectivity, I want to suggest, that gives rise to the real threat to trust in the judiciary that is wrought by social media. Because a culture which maintains that all evaluative judgments are expressions of subjective personal preference or attitude will not be able to accept that some evaluative judgments are in fact the application of objective laws and not the whims and preferences of individual persons. And again, the problem here is not simply that social media promotes the view that individual judges are acting in accordance with their personal preferences, attitudes, or feelings. The problem is that the very medium of social media promotes the view that they are incapable of doing otherwise. Namely, that a significant part of the community now assumes that it could be no other way. Of course, the judge decided the case in accordance with his or her own preferences, attitudes, and feelings. After all, that is true of all evaluative judgments. Why should a judge be any different? Well, so much for McIntyre's diagnosis of our predicament. Is there any way out of it? No doubt the impact of social media and artificial intelligence on our culture is broader than the currently waning trust in the judiciary and other governmental institutions. And so any solutions must ultimately go deeper than the institutions themselves can achieve. But there are nevertheless some things that we can do. And to that end, McIntyre's revival of Aristotelian virtue has something to teach or at least remind us. Part of McIntyre's central thesis was the fact that whether we like it or not, each of us is the bearer of a tradition or traditions, which he defined as, quote, a historically extended, socially embodied argument, and an argument precisely in part about the goods which constitute that tradition. And the goods internal to that tradition in turn serve to define the virtues necessary for both sustaining the tradition itself and the individual lives that exist as part of it. As McIntyre put it, quote, lack of justice, lack of truthfulness, lack of courage, lack of the relevant intellectual virtues, these corrupt traditions, just as they do those institutions and practices which derive their life from the traditions of which they are the contemporary embodiments. To recognise this is, of course, also to recognise the existence of an additional virtue, one whose importance is perhaps most obvious when it is least present. The virtue of having an adequate sense of the traditions to which one belongs or which confront one. As judges and lawyers, we are all bearers of a particular tradition or traditions, which sets its face, no doubt, against the emotivism of our age, but for which we are chiefly responsible for upholding. We must therefore have an adequate sense of the traditions to which we belong and those which confront us. In this respect, we, judges and lawyers, should not think of ourselves as immune from the emotivism and expressive individualism that characterise our age. These phenomena, which increasingly lead to the mark of personal identity and integrity being a person's display of their own preferences, affect us as much as they do around us, particularly if our display is likely to garner approval or adulation. Such display, however, no matter how much the subject of approval or adulation, is itself corrosive of the trust upon which the legitimacy of the judiciary depends. Because, as I observed earlier, trust in the judiciary, the legal profession, or any other governmental body is necessarily institutional and not personal. And just as the trust to which each individual judge can lay claim is derived from that institutional trust, so it is necessary for the individual judge to recognise that he or she is responsible to maintain that trust precisely as institutional trust rather than personal trust. Paradoxically, then, insofar as we make a display of our own preferences and attitudes as a mark of our integrity or professional trustworthiness, we undermine the institutional trust due to the judiciary as a whole. We feed into the corrosive notion that all evaluative judgments are merely the expressions of subjective personal preference. That is why I would suggest, to pick up a point that John Tsoulis raised in a question this morning about celebrity judges, why I would suggest the celebrity judge, or what I've written down here as the hero judge, can be so dangerous to the judiciary as a whole, and indeed in the long term might be more dangerous than the bad judge. The bad judge, or the corrupt judge, is clearly an exception, a betrayal of the public trust reposed in the institution of the judiciary. The hero judge, however, sets himself or herself up as a rival to that institutional integrity, and so, even if subtly so, serves only to undermine it. As Chief Justice Gageler recently described the constraints upon individual members of a court, quote, "The foundational conception is that the function of declaring the law is vested in the court rather than in the justices who from time to time comprise it. This constraint, as his honour described it, is an, quote, institutional imperative." I would only add this, that institutional imperative extends to each and every aspect of the judicial function. The judicial function and all judicial power is vested and is exercised by the court rather than the judge who from time to time comprises that court. We should be careful not to pretend that it is otherwise. That is not to say that personal integrity and personal adherence to the virtues inherent in our legal traditions are not essential to the discharge of judicial office or membership of the legal profession. Of course they are. As McIntyre observed, the absence of those virtues not only corrupts traditions, it also corrupts the institutions that derive their life from those traditions. Personal integrity is therefore essential, but it is precisely as institutional integrity that personal integrity must be manifest, not over against it. To use Professor Sokolowski's phrase again, we must at all times seek to maintain the elegant anonymity of our trustworthiness. Another aspect of McIntyre's conception of a tradition may also provide some focus for our response to the other technological change or revolution that we face, artificial intelligence. McIntyre's conception of tradition, to be sure, did not conceive of tradition as a form of antiquarian conservatism. As he said, it is rather the case that an adequate sense of tradition manifests itself in a grasp of those future possibilities which the past has made available to the present. Living traditions, just because they continue a not yet completed narrative, confront a future whose determinant and determinable character, so far as it possesses any, derives from the past. What might we, as inheritors of our legal traditions, draw from our past that may assist us in our response to artificial intelligence and the use of artificial intelligence in the legal process? At least for those of us from the common law tradition, the answer may be found in the common law's strong preference for orality. its preference for both oral evidence and oral advocacy. While the use of written evidence and written advocacy has significantly expanded in recent decades, and epitaphs are occasionally written for its ultimate demise, the oral tradition of the common law refuses to die. Indeed, in some quarters, there has been a greater return to orality. In my own jurisdiction, for example, a procedure whereby written statements constituted the evidence of witnesses in civil cases that had been in place for several years has now been replaced with a return to oral evidence. Significantly, that change was a consequence of judicial disquiet about the authenticity of written evidence, in which the reliability of written material could no longer be assumed to reflect the words and recollections of witnesses themselves. In other words, the authentically human element in the judicial process was in danger of being lost, and the remedy was to be found in a return to the traditions past. In the field of advocacy, the common law's traditional preference for orality has related more to intelligibility and immediacy. To paraphrase Socrates' complaint to Phaedrus referred to earlier, when you ask written submissions anything about what they say from a desire to be instructed, they go on just telling you the same thing forever. It's perhaps for this reason that I personally have found that an ounce of oral dialogue is worth a pound of written advocacy. The greater intelligibility and immediacy of oral advocacy again serves to emphasise the interpersonal nature of the judicial process. Each of these concerns reflected in our legal traditions, namely authenticity, intelligibility, and immediacy, then, derive from their essentially human and personal character. They make clear that the objectivity upon which the rule of law rests depends upon human agency for its expression, and also that to be impartial or objective does not mean to be impersonal. On the contrary, it is precisely in the exchange between persons that true objectivity is to be found. While the challenges posed by artificial intelligence to the legal process are no doubt different to those of the past and must be met with new solutions, the underlying concerns are the same: authenticity, intelligibility, and immediacy. Our legal traditions have dealt with these concerns before and has developed rules designed to ensure that the human character of the law and the legal process is retained and preserved. When new technologies have produced new forms of evidence, for example, the law has adopted an incremental approach to the acceptance of these new technologies, which has always ultimately required authentication by human beings before it can be relied upon. Once established, the reliability of new technologies, such as photographs, sound recordings, and DNA evidence, then have been more readily relied upon without the need in every case for human superintendence or authentication. But it remains there for those cases where it is necessary. No doubt, as I've said, artificial intelligence introduces new challenges. Its capacity to mimic human speech and even human reasoning are such that its essential artificiality may be more difficult to recognise. In many respects, it is that difficulty to distinguish one from the other that leads to the distrust we instinctively feel, or at least we say we feel, over artificial intelligence. Distinguishing between the artificial and the real, however, has always been the role of the legal system and of the institution of the judiciary. Indeed, as I've earlier proposed, it is the capacity to distinguish between the real and the unreal, the capacity for objectivity, upon which trust in the judiciary ultimately rests. In the end, it may be then that should we, as a judiciary and as a legal profession, rise to the challenge of artificial intelligence by maintaining and exercising our capacity for objectivity, our human capacity for distinguishing between the real and artificial, that it will be precisely there that our institutional trustworthiness and the trust upon which our legitimacy rests may be renewed, in which it may be preserved. Thank you.
Thank you, Peter, for this solid and very exhaustive presentation of your views on the, let's say, the intersection between technology challenges and justice. And if I can take two very short key takeaways, I understand that on social media, you basically support that it undermines the public trust by encouraging emotional reactions and personal views over reasoned legal judgment. And apparently the solution lies in reaffirming the judiciary's institutional character. And as to AI, I understand that it challenges the legitimacy of the legal process by mimicking human decision-making. But on the other hand, I guess you are optimistic that the judiciary tradition of real-time dialogue and fact-finding equips it in a responsible way to manage and actually integrate AI in the process. So, which is very optimistic in my view too. Cautious of time, I will pass the floor to our second speaker. This is Louiza Protopapa. Louiza is a prominent Cypriot attorney. They don't wait to finish. So
They brought her public with her.
okay, so, and she's the current president of the Limassol Bar Association. She runs her own practice as a managing partner, where he brings over 2 decades of experience in corporate, commercial, civil law, and she has a distinguished record as both a litigator and a legal strategist. Prior to that, she was a partner in a respected law firm before founding her own practice. Apart from advisory work, she has represented clients in all levels of Cypriot courts and has participated in arbitration proceedings before the ICC International Court of Arbitration in Switzerland. Louiza read law at Aristotle University in Salonika and admitted to Cyprus bar in 2002. To none surprise for a Cypriot lawyer, she is fluent in Greek and English, and from her position as the president of the bar, aims to continue leading with a vision for institutional transparency, professional excellency, and the modernization of the legal practice in Cyprus. So I'm certain that tokens of such valuable and noble causes for leadership will be reflected in your speech. You have the floor.
Thank you very much.
We are all ears, and I would urge you to stick to the 20-minute rule, as we are ahead of schedule. Thank you. Behind schedule, sorry.
So, in a world where people trust TripAdvisor more than their governments, maintaining public confidence in the judiciary system and institutions is no small feat. Yet, judicial legitimacy, the belief that courts are fair, impartial, and operate within the rule of law, remains essential to any functioning democracy. Without it, the whole legal edifice starts to look less like a courthouse and more like a house of cards. But today, this legitimacy faces challenges. We're spiraling into a world of viral tweets, AI-generated deepfakes, and social media legal experts. So, how did we get here? How badly could things go? What can we and should do about it? Judicial legitimacy isn't just a nice-to-have concept. It's what keeps people showing up in courtrooms instead of taking justice into their own hands or elevating themselves to keyboard ninjas through social media commentaries. Public confidence enables courts to issue decisions that are respected even when they are unpopular. A judiciary perceived as fair ensures compliance with the law, acceptance of court outcomes, and crucially, the peaceful resolution of disputes. Once this perception erodes, every verdict risks being seen as biased, politically motivated, or even illegitimate. And that's when things start unraveling fast. Moreover, legitimacy is a self-reinforcing cycle. Public trust leads to acceptance, which reinforces judicial authority, which strengthens democratic governance. Break that cycle, and the rule of law loses its authority. Social media is often described as the new public square, in honor of the ancient city that is hosting this brilliant event. The ancient agora was the primary meeting grounds for Athenians, where members of democracy congregated affairs of the state and where business was conducted. Further, it was a place to socialize, watch performance, and listen to famous philosophers. So this new agora created online some days feels more like town's angriest pub at closing time. Judges, once protected by the dignity and distance of their role, now find themselves in the crosshairs of Twitter mobs, Facebook rants, and TikTok legal experts. Misinformation poses a central threat to judicial legitimacy, especially in an era dominated by 280 character posts and TikTok soundbites. They reduce complex legal decisions to misleading headlines or out of context fragments. This distortion can stem from genuine misunderstandings, such as journalists misinterpreting rulings, or from deliberate manipulation by individuals or groups seeking to steer public outrage. Increasingly, judges are targeted through tactics like doxing, the malicious publication of personal details, false accusations, and even threats of violence. I think it was Judge that said so yesterday that in America there was a threat against other judges, another judge from her house, even. The rise of AI-driven misinformation has added a new layer of risk, with sophisticated tools capable of generating fake videos or deploying bots to flood digital platforms with content designed to undermine public confidence in judicial independence. These tactics are not just the work of lone actors, but may also be weaponized by political entities, foreign states, or interest groups with vested agendas. Yet, as any powerful tool, AI is not inherently malevolent. It can also be part of the solution. The same technology that enables the spread of disinformation can't be harnessed by courts to safeguard judicial legitimacy. With the right approach, AI tools could monitor social media for emerging threats, analyze online sentiment around judicial decisions to detect reputational risks, and even counter falsehoods through automated fact checking and the distribution of accurate, accessible summaries and complex rulings. However, this introduces a delicate challenge. How can courts engage in digital self defense without encroaching on freedom of expression or appearing to police public discourse? This question becomes even more pressing when considering the broader dilemma of transparency versus protection. Transparency is essential to legitimacy. People are more likely to accept a decision they understand. But in the age of viral outrage and weaponized narratives, overexposure can backfire. Striking the right balance requires structured communication strategies, protection protocols for judges and court personnel, and investment in public legal education. Courts must proactively explain their decisions in plain language, ideally through trusted spokespersons or judicial communication offices. And perhaps, beyond democratic and internal domestic reforms, it is time for an international conversation about the ethical use of AI in judicial contexts with two critical and important questions. First, should there be global standards governing now how AI is used to monitor, support, or critique judicial systems and institutions in general? Based on a publication made by White and Case in May 2025 about how AI is being regulated in the United States, one can clearly identify that there is no comprehensive federal AI regulation in the US. Overall, AI in the US is regulated through a patchwork of existing laws, sector-specific rules, and emerging state laws, with federal legislation remaining cautious to preserve innovation while addressing privacy. Accordingly, there are currently no specific or unique federal imposed obligations on developers, users, operators, and/or deployers of AI systems. According to a global research published in 2025 by YAP, a policy-neutral not-for-profit association founded in 2000, governance and digital response. On the 1st of August 2024, the EU AI Act entered into force and shall be completed in terms of compliance in various states up and until 2030. The EU's Invest AI initiative is a significant shift. It's not just regulation, it's a bold economic strategy aimed at positioning Europe as a major player in artificial intelligence. Mobilizing 200 billion for AI through a combined investment from the EU and private partners, spanning the full AI stack, from research and startups to industrial deployment and infrastructure. Further, the EU is deploying a 20 billion fund for AI gigafactories. These EU actions are a response to the US's 500 billion Stargate project and China's AI surge, aiming to close Europe's AI infrastructure gap, especially against US and Chinese dominance. This EU strategic focus makes Europe a serious contender in AI innovation and ethical tech. The second question that rises is that to what extent should tech companies be held accountable for content that erodes the legitimacy of judicial systems and institutions in general? For example, Denmark has announced plans to strengthen protections against digital identity impersonation with a pioneer law in Europe. The proposed legislation presented to Parliament aims to affirm individuals' rights over how they look and sound online. Once passed, it will allow citizens to request the removal of online content shared without their consent. Those affected by violations could also seek compensation under the new rules. But these should not stop here. More actions like the one in Denmark have to take place, not just for the protection of individuals, but also for the protection of judicial systems and institutions. What is for sure is that digital age won't slow down for the judiciary. With the right mix of vigilance and transparency, we can preserve the legitimacy of the courts in an era of hashtags and hallucinating AI headlines. But what is the lawyer's role in today's digital era? The above are not a task performed by the judiciary alone. What is the role of lawyers in this digital age, and what is their role in judicial legitimacy under the social media and AI threats? Let's start with a confession. Lawyers aren't exactly known for being social influencers. Although there is at least one TikTok divorce lawyer with 500,000 followers somewhere in the world explaining why you should never text your ex. But in today's world, lawyers are increasingly active on social platforms, and more of us are using AI tools in our daily work. The question is, are we helping or hurting judicial legitimacy in the process? The stakes are high. Judicial legitimacy is the lifeblood of the rule of law, the glue that keeps society from falling into chaos. But in this digital era, lawyers, once mere interpreters of the law, have also become digital actors, narrators, and sometimes accelerants, unintentionally, of public mistrust. So let's examine how lawyers are contributing to this new landscape, and more importantly, how we can make sure we are part of the solution and not the problem. In the 20th century, a lawyer's reputation was built in court. In the 21st, it's shaped by LinkedIn posts, client reviews, and if things go sideways, in some jurisdiction, Twitter threads dissecting your courtroom blunders in real time. More lawyers around the world could engage with the public directly, commenting on ongoing cases or related newspaper articles, giving legal hot takes, even calling out judicial decisions. The result? Increased visibility of the judiciary, but also vulnerability. When legal commentary spills into populism, even the most balanced judicial decision can't be drowned in outrage. Social media offers lawyers a megaphone, and many are using it, sometimes for education, sometimes for ego. But whether on Instagram or Facebook, the legal profession is now shaping public discourse on justice outside the courtroom. Used responsibly, this is a gift. Lawyers can explain complex rulings in plain language. They can counteract disinformation in real time. They can highlight abuses and gaps in the system that deserve reform. But used irresponsibly, it's a ticking credibility time bomb. Lawyers who frame court decisions through partisan or emotional lenses can polarize public opinion. Speaking prematurely about pending cases risks prejudicing proceedings. Inflammatory or misleading posts can go viral far faster than any correction or clarification. In some jurisdictions, professional rules are catching up. Issuing guidance on lawyers' contact on social media, emphasizing accuracy, confidentiality, and respect for judicial integrity. I believe we have reached the times when this is no longer just optional. It has become mandatory. So, how are lawyers also using AI besides social media? The rise of legal AI tools has been a double edged gavel. On one hand, we have ChatGPT, Harvey AI, CoCounsel, and other platforms helping lawyers draft contracts, predict case outcomes, and summarize judgments in seconds. On the other hand, we've seen examples where lawyers, perhaps too trusting of technology, submit briefs citing non existent cases generated by AI hallucinations. In a nutshell, AI is helpful until it cites a case from Hogwarts Court in which Harry Potter turned an argument into a legal principle. So, yet a deeper challenge lurks beneath the surface: the legal profession's own cultural resistance to change. Lawyers trained in precedent and precision often approach technological innovation with caution and sometimes outright skepticism. This conservatism, while valuable in upholding standards and safeguarding ethical practice, can also hinder timely adaptation. As AI tools, digital communication methods, and online public engagement evolve rapidly, a divide is emerging between those legal professionals who embrace these developments and those who struggle to integrate them. This two speed profession risks not only creating disparities in service delivery and public engagement, but also undermining collective credibility. When some lawyers skillfully harness technology to clarify, educate, and defend judicial integrity, while others lack or misapply tools they don't fully understand, the profession risks appearing fragmented and out of touch. Addressing this imbalance is essential, not just for the internal cohesion of our profession, but also for preserving public trust in the legal system itself. Artificial intelligence offers significant advantages for legal professionals, notably in enhancing efficiency by expediting tasks such as drafting, legal research, and due diligence, and it also improves access to justice, enabling solo practitioners and smaller firms to deliver competitive legal services, helping demystify complex legal rulings through simplified AI-generated summaries, and making the law more accessible to the public. However, these benefits are accompanied by important ethical and professional risks. AI tools may produce inaccurate or misleading content, as they cannot reliably distinguish fact from fiction. And over-reliance on artificial intelligence by replacing human judgment with algorithmic convenience can erode professional standards and critical thinking. We all know that courts, at least across the United States, are beginning to address attorneys' use of generative AI in drafting court documents. A handful of jurisdictions have enacted proposed rules requiring lawyers to disclose AI assistance in filings, largely spurred by high-profile incidents where AI-generated content included fake case citations. These new rules vary by location. Some mandate explicit disclosure and certification of human review, while others caution against AI's unreliability, but stop short of requiring disclosure. So yes, lawyers can use AI, but like chainsaws, just because you can use one doesn't mean you should, at least not without training. So, how lawyers can strengthen judicial legitimacy? Here is the plot twist. Lawyers aren't just potential threats. We are also the best line of defense. Lawyers can help restore and protect judicial legitimacy by becoming responsible narrators, using social platforms to explain and not inflame, using AI ethically by vetting out AI outputs, cross-checking sources, and treating technology as an aid, not a replacement, engaging with the public transparently, promoting informed dialogue about core decisions, processes, and principles, and calling out bad actors, condemning the use of deepfakes, AI-driven defamation, and social media attacks on judges and their decisions, whether by the public, politicians, or fellow professionals. These won't be easy. It requires attentiveness, judgment, and a dash of humility. But if lawyers don't lead in protecting judicial legitimacy in the digital age, who will? Let's be candid. The courts will not survive the algorithmic age if we treat them like legacy institutions immune to disruption. Judicial legitimacy cannot be preserved with silence, opacity, or tradition alone. It must be actively defended, and lawyers are uniquely placed to lead that defense. So let's be cautious when we type, thoughtful when we post, and skeptical when AI suggests that a 2002 Supreme Court about parking tickets overturns the Constitution. In a world of rapid change, the lawyer's role hasn't diminished. It's expanded from advocate to public educator, from courtroom counsel to digital truth teller. So let's use that power wisely. And yes, the PowerPoint presentation I shared with you was created using AI as a tool, guided hopefully by human intelligence, and with any luck, without any hallucinations, to deliver a speech that is truly human-made. Thank you very much.
Thank you, Louisa, for this very eloquent presentation. I think in your last point, you summarized the key takeaway from your speech, that the courts will not survive the technological thunderstorm, and they are not immune to the change, and they need to defend themselves. And it's very glad to hear that lawyers have a role to play there by having, let's say, a higher bar of responsibility towards the other people, and they can act in a professionally moral way, but also as a legal educators, giving the good example. I'm afraid you have to wrap up this session. We are behind schedule, so we'll not take any question. That makes the panel like a food without salt and pepper, but that it is. So be it. I will have to pass the baton to the next panel. So I will be discussing a very interesting topic, like all the topics in the summit. Best practices in safeguarding the rule of law domestically and internationally in the face of global threats. I will ask the moderator, George Papadopoulos, advocate and legal counsel to the Athens Bar, to take here the floor and present the speakers of this panel. And of course, as you understand, I have bad news for you. There's no coffee break. Huh? Thank you.